And welcome back in for another video, y'all. Let's have a seat. We are here to get into a newly filed court document with an ongoing litigation case that is approaching quickly, November the 17th to be exact. All right, now this particular court document that I'm going to read today is coming out of the Central District of California. This was filed by Movent Milagro Elizabeth Cooper, and we're going to get into it, y'all. We're going to get into it. Now, before we actually start, copyright disclaimer under Section 107 simply saying that, hey, this is fair use. I am not a paralegal. I am not an attorney, and I am not a judge. I am simply saying that, hey, we have common sense and we can read. Okay? Now, without further ado, let's go ahead and get into the motion to compel Ryan Reagan Stogner to comply with Rule 45 subpoena. All right, so let's scroll down. All right. So, memorandum of points and authorities introduction. This case is pending in the United States District Court for the Southern District of Florida. On date, Movent issued and served a subpoena pursuant to Federal Rule of Civil Procedure 45, commanding officer Ryan Reagan Stogner, an employee of Los Angeles Police Department, to appear for deposition within 100 miles of his residence in Lancaster, California. Despite valid service and tender of witness fees, Officer Ryan Reagan Stogner failed to comply. The subpoena is valid, enforceable, and within the geographic limits of Rule 45C. Movent respectfully requests that this court, as the compliance court, order Ryan Reagan Stogner to appear for deposition and, if necessary, impose contempt sanctions. All right, so factual background. On August the 15th of 2025, the Florida court issued a subpoena for Ryan Reagan Stogner. The subpoena commanded attendance at deposition on August the 25th of 2025. And as y'all can see there, that's the address, within 100 miles of his residence. Movent's process server personally served Ryan Reagan Stogner on August the 21st of 2025 after several attempts. At the time of service, Movent tendered the required witness fee and mileage under 28 USC 1821. Ryan Reagan Stogner did not appear on the date noticed after communicating that he preferred to appear in person rather than Zoom. I offered the Zoom option because he said he was off duty due to medical leave. I explained to him via text that this is a civil matter and not a criminal matter, and that his conduct is not in question, nor is he being sued. I explained that he felt the need to get an attorney. He could call private counsel, or the police protective lead might represent him. I received a call from an individual named Lawrence, who purported to be an attorney with the police protective lead on August 22nd. He stated that he could not represent Stogner because it was a civilian matter. He also stated that he advised Stogner that he needed to appear for the deposition. And when I said he could appear by Zoom, he said that Stogner said he would prefer to come in person. Defendant attorney booked the conference room and a court reporter and sent out notices to opposing counsel. Stogner texted defendant's attorney at 10:02 a.m. after the start date of the deposition, stating that his supervisor told him he didn't have to attend because he was on leave. I had offered to make accommodations by offering a Zoom deposition, but Stogner has failed to communicate or comply. I communicated with his attorney via a telephone, both before and after the deposition. The attorney from the Police Protective League said he couldn't represent him because it is a civilian matter. I spoke to another officer who called on a private number, and she gave me the number to call the police discovery unit, which I did and left a message twice. They did not answer their phone or return calls. Finally, I requested a meet and confer with the city attorney in charge of risk mitigation for the LAPD and copied Detective Stogner on his LAPD email and have not received a response. Legal standard. Rule 45C authorizes deposition subpoenas within 100 miles of a witness's residence or employment. Rule 45D2BI permits a party to move to compel compliance in the district where compliance is required. Rule 45G empowers the court, this court, to hold in contempt a person who fails without adequate excuse to obey a subpoena. And then argument. The subpoena was properly issued from the Florida court where the case is pending. Service was properly executed and included tender of statutory fees. The deposition location was within the geographic limits permitted by federal Rule 45C. Ryan Reagan Stogner has no valid excuse for noncompliance. His testimony is material to Movin's claims, and requiring his appearance imposes no undue burden. Enforcement by this court is necessary to uphold the integrity of the judicial process. Relief requested. For the foregoing reasons, Movin respectfully requests that this court issues an order compelling Ryan Reagan Stogner to appear for deposition at a time, date, and place within the Central District of California to be set by the court or agreed upon by the parties. Directing Ryan Reagan Stogner to produce any documents or materials identified in the subpoena. Awarding Movin reasonable expenses, including attorney fees and costs, incurred in bringing this motion pursuant to Federal Rules of Civil Procedure 37A5 and 45G, issuing an order to show cause requiring Ryan Reagan Stogner to appear and explain why he should not be held in contempt of court for failing to comply with the duly issued subpoena. And as y'all can see there, lastly, number 5, granting such other and further relief as the court deems just as proper. In conclusion, as y'all can see there, for the foregoing reasons, Movin requests that this court grant the motion and compel Ryan Reagan Stogner to comply with the subpoena. And that's it of this particular court document. Now, there is another one, and this is going over the actual costs. So we're going to get into that. All right. So we're just going to touch base as this loads. This is the declaration of Ronda Dixon, and this is basically going over the attorney fees and costs that she has endured. As this loads. All right, there we go. So as y'all can see here, we're going to get down here. Now, this is something. So Ronda Dixon charges $500 an hour. All right. Now, due to this particular instance pertaining to Officer Stogner, she spent a total of 14.2 hours, resulting in $7,100. And as y'all can see at the bottom, it says, in addition, Movin incurred $1,186 in out-of-pocket costs, including service of subpoena, court reporter appearance fee for non-appearance, and filing fees. Accordingly, the total amount of attorney fees and costs sought is $8,246. Now let's get into the actual fee breakdown here. So witness fees and mileage, $40. Service of process, $160. Court reporter fee, $541. Conference room rental was $445. And as y'all can see here with attorney fees, she spent a total of 14.2 hours at $500 an hour rate, resulting in $7,100. And that's how we get to $8,246 at the end. All right. And as you can see here, this is the attorney time log. This is her hour breakdown, resulting in 14.2 hours. Okay. And then this is what she says here. I run a Dixon council for Movit, hereby declare on August the 25th of 2025, Officer Ryan Reagan Stogner failed to appear for his deposition despite being properly served with a subpoena and tendered witness fees. Immediately after the non-appearance, I reached out to Officer Ryan Reagan Stogner's counsel from the Police Protective League, the LAPD Discovery Unit, and the Los Angeles City Attorney's Office. I sought to secure a new deposition date voluntarily without court intervention. Despite multiple communications by email and phone, I received no response from any of these officers or representatives. No explanation, objection, or protective order request was provided. I made these efforts in good faith to resolve the matter without burdening the court, consistent with Federal Rule of Civil Procedure 37A1 and Central District of California Local Rule 37.1. And that is that. All right. Now, we do have another, well, in case you missed it, this was filed a while ago. However, I did miss it, but I just wanted to go ahead and briefly show it. And we're going to get into this. This is DJ Academics' motion to compel. Now, this was filed in the District of New Jersey by Quinn Emanuel. Y'all know who Quinn Emanuel is. All right. And this is this particular court document. Now, if you actually want to get into that particular document, I did post it today. Look on the top left-hand corner of your screen. You see a QR code. That is direct link to my X page, formerly known as Twitter. And you can divulge in the 183 page motion to compel with exhibits. Okay, so it's the actual court document, and then they have the exhibits attached below. So you can divulge in it. Again, top left-hand corner of your screen, click on that QR code or scan that QR code, go directly to my X page, and you can divulge in those court documents. All right. Now we're going to go ahead and get out of here. I just want to thank everyone for getting me past 500 subscribers. I appreciate you all. Thank you so much. I am on the road to 1,000 now. So I'm steadily pushing, trying to crank out these videos. But I want to say this. Hit the like button. It's free. Hit the subscribe button. It's free. Hit the share button. It's free. Thank you so much. Again, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I hope y'all have an amazing day today. And until next time, see y'all soon. Peace.